Adjournment request, if any, from item number 1 to 17.
Declare, please, Lordship. For item number 1, it is a writ appeal, Lordship. We will file the corrected and proper copy of the memo appeal, because in the meantime, appellant has expired. Today itself, I will file it before the registry.
Last time amended procedural, our time was granted to file an amended.
Yes, Lordship. I offer my apology. Today, I have got the copy only from the parties, Your Honor. I will file today itself, Your Honor.
And the concept of
Yes, with copy to the other side.
appellant will raise one more opportunity to place on record the amended cost item as ordered by this court, ordered by this court earlier.
Yes, sir. Today itself.
994 is granted.
Yes.
Let's start with new week. Yes.
Well, I beg to mention item 15 and 16. These two matters, Lordships on the last occasion decided to take up in the administrative side. But I am yet to get the instruction from the registry regarding pay parity of
Pay.
system analyst and system officer.
So who moved this application?
My lord, I moved in application because I haven't got any.
Inform.
Yes, my lord, I
I
have
got the petition,
taken the
my lord.
consent. my lord.
View it.
The
Yes.
only thing that my lord, date may fix, my lord, on the
Whatever day.
on the hearing day, my lord.
Whatever day.
Yes. Much obliged.
May I please, Lordship, with the consent of the other side, beg to mention item number 12, Lordship.
Adjourn.
Conduct, yes, Lord.
Lordship, there is a request with regard to yesterday we have redressed writ appeal, and there is the eviction on 10th January, Your Lordship. Kindly fix some date.
Which matter?
Yesterday we have redressed. A writ petition is not filing
Not
number.
registered.
Right.
You are not, still that appeal is not registered.
It is not registered. Yesterday,
Without getting it registered, how you?
it
ask
is a
for
filing.
listing that
Yesterday
case?
we have redressed it, Your Lordship. Redressal was done on yesterday. Defect was removed yesterday, Your Lordship. It was filed earlier, Your Lordship.
Been listed, no?
Your Lordship. Because the 10th January
Case
is
is not registered, how can we ask them to get a case listed?
No. Yesterday it has been, Your Lordship, but till time no number has been given, Your Lordship, of the writ appeal.
Wait for a day, if you have removed the defects
No,
yesterday.
it has been removed yesterday,
You
Your
have
Lordship.
removed the defect yesterday, they'll register it and give the number.
Some date may be, some date may be fixed, Your Lordship. Because 10th January is eviction proceeding, Your Lordship, after vacation, Your Lordship. After vacation, Your Lordship,
That railway vendors,
railway vendors, Your Lordship.
there is nothing. This
Because
Supreme Court,
10th
up to Supreme Court, you have lost the
No,
case. What
They-
remains?
That is another matter. They are the,
Whether one and the same.
they are the lease,
There is no provision for renewal, for
but Your Lordship, for
and you
the,
are seeking renewal again. This court has
No,
ruled that no provision of renewal.
that is not the
there.
matter of the renewal, Your Lordship. It is the lease land, Your Lordship, and they have given the notice. Kindly fix some date, Your Lordship. Your Lordship,
January may date.
10 January,
8 of January.
deeply obliged, deeply.
Adjournment request from item number 18 to 24.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item 23, lordship. I have circulated yesterday the adjournment
Adjourn,
request,
adjourn.
lordship.
Adjourn. Adjourn.
Yes, lordship, deeply obliged.
Please, your lordship, with the consent of the other party, I'd beg to mention item number 20, 21 and 22, your lordship.
Adjourn.
Yes.
May I please, your lordship, I beg to mention item number 24 with the consent of other side.
Item number
24
20.
with the consent of other side. Matter may come after
I have not
verification.
moved any application.
Lordship,
Adjournment slip, I have not circulated adjournment slip.
sorry, lordship.
We are asking something, why have you not circulated adjournment slip in advance?
Sorry, lordship.
Adjourn. When
Blessed.
the facility is there, either you move that application, otherwise we are going through the files and again you are asking for that adjournment.
Obliged.
Any other request?
May it please, your lordship. My lord, I have filed a writ appeal on 11/12, my lord. There is some urgency, my lord.
What is the
Before-
urgency?
Urgency is that in a contractual matter, my lord, After review, my responsive technical bid has declared as non-responsive, and private respondents non-responsive bid has been declared as
Learned single judge has dismissed your petition.
dismissed the petition. Against that, I have filed, and it has numbered.
In contractual matters, there is limited scope of this court.
Yes, only I can take, my lord,
Thursday.
before Thursday, March onwards.
Lordship, may I pray, Lordship? An urgent writ appeal has been filed, Lordship, yesterday. That is, filing number is there. It is very urgent regarding eviction and land acquisition and eviction, Lordship. It is I have filed a writ petition before the learned single judge, and that was interim order was refused, Lordship. That is why maybe
Is refused, and in that you are
Lordship, with an erroneous view, Lordship. Lordship. All right. Tomorrow, Lordship.
Thursday.
All right.
Daily list for orders, item 2.
Yeah, please, Lordship.
You have not taken any steps.
Lordship, we want to withdraw this.
Wants to withdraw, dismissal withdrawn. Here, resultantly, the connected writ appeal. MC number 40 oblique, connected MC number 40 oblique 2024 is also dismissed as withdrawn. Yes.
Item 3.
No steps.
Lordship already appeared.
Confirmation as per the above number. Sections have not been.
Already he has
appeared, my lord. There's a delay of
112 days.
12 days. There's no explanation in the IA. Leave it.
That's all.
I'll leave it to that.
Okay, the matter comes upon for consideration. What's wrong in the order of the learned single thing?
Okay. On the basis where he has registered the sale deeds, this is the official documents. These official documents need not be proved, Lordship. First of all,
Official documents need not to be proved. Where is the question of
these are
provision of document here?
because it is a
The allegation against the petitioner that while registering the document, he has undervalued, he has not gone into the undervaluation of the property. And basis of which that one communication dated 5/12/2003 or 15/12,
Right.
whatever the date may be,
Lordship.
that has not been taken into consideration. This is what the allegation.
First allegation. Second allegation is, Lordship, page 42, Lordship.
Yeah.
Section 27, violation of section 27A of Indian Stamp Act, Lordship.
What was that violation?
That was that if there is some dispute or he has some doubt regarding the valuation of the land or proper instrument, he has to refer the matter to the district register.
But where is the doubt or?
Yes, from the
that is,
from
he don't have, he was not having any doubt in his mind.
sorry, from his so-called reply, from that can be ascertained, Lordship.
Read.
That page 46 of the main paper.
Read.
The both the parties in the deeds, seller and purchaser personally appear before a delinquent and satisfied him on the matter of consideration of amount valuation of land set forth in the deeds. The lands in question were valued lower than the normal market price, as the lands were shown to exist in a very low-lying areas, requiring deep earth filling, involving heavy investment, and further most of the lands were no having direct accessibility to the main roads. Considering these two main factors, price of the land were fixed much lower than the normal market price by the buyer and sellers as deposited by both the parties being personally present before him. Second, that while accepting the registration of the land sale deed, the delinquent did not have any reason to believe that valuation of the lands were fraudulently undervalued by the executants, as transferees named therein themselves were personally present before him, who had also supported the facts. Then next, that the delinquent being registering officer appointed under the Registration Act have been unable to conduct any independent inquiry under Stamp Act to ascertain the valuation of the land. Therefore, he had no other reason to refuse the registration deeds which were presented for registration by the executant, having complied with the requisite formalities as laid down in the Registration Act. That the registration is allowed on good faith. He had not inquired whether there is any documents or not. Good faith on the sole testimony of the buyers and sellers who were under obligation to set forth in their.
The department found that these properties were undervalued, and despite that they have been registered, whether those documents were impounded by the collector.
Lordship, this was communicated.
Exercising the power under section 27.
These documents were communicated to the office of the district registrar, Lordship.
If those documents were impounded or the collector has issued notices to those persons that this property was undervalued.
No, that is in a different part, Lordship, because he can.
Unless you come with this conclusion.
This inquiry was conducted on the basis of some allegations, Lordship, complaint from some public, Lordship. That is
public, but and who has proved that the witnesses have not said anything?
They have not stated anything.
Initial burden was discharged by the department or not?
Lordship.
Initial burden was discharged by the department or not? When these documents were registered?
In the year 2007, Lordship.
2007.
Lordship.
Not 2007.
Yes. Huh? No, second.
2007. What is that statement of allegation?
The record will reveal, Lordship. Here, not the impugned order.
The date of this,
The dates of the
Dates
sale
are
deeds
not
are not
mentioned.
mentioned.
Huh?
Date of the sale deeds are not mentioned.
dates of the sale deeds are not been mentioned.
Yes, dates are not mentioned.
Numbers are mentioned, Lordship.
Numbers are mentioned, but when?
And the Malad, the contention with regard to that circular, Malad, is an internal communication between two departments.
Just a minute, first of all, certain,
That-
the dates
Imp-
of the registered deed, the
that-
period in which he has got this,
The impugned order page 80, Lordship.
80.
80, Lordship. Paragraph 7, Lordship.
Yeah.
Learned, no, this becomes second or page. Learned counsel for the petitioner has submitted that no presenting officer was appointed and nothing could be established in the inquiry, and the findings are based on presumption. He reiterates that while registration of the concerned deeds were done in March 2007, Lordship.
This notification dated 5/12/2023 is
2003.
page number 51.
Page 51, yes, Lordship. সেইখিনিয়ে আছে।
Oh, no, no, page number এটা নিলিখে।
Yes.
Delay may be condemned and delay may be.
Why delay, we have heard on merit.
Otherwise,
We are condoning the delay.
there is a admission and omission on his part, Lordship. Page 47, Lordship.
Page 47, yes.
Paragraph 3. That however, the alleged omission on the part of the delinquent officer was neither deliberate nor motivated, but brought about the circumstances beyond his comprehension. Therefore, the omission being a bona fide one may please be condoned, considering the same as human error. Being a responsible officer, Lordship, he cannot take this
Principal
plea.
defense was that whatever the communication that 5/12/2023 was never served upon him or never communicated. So the inquiry during the course of inquiry, at least this must be expected from the department, that this communication was very much in the knowledge of the
Delinquent.
delinquent. Despite that, he has done this.
Lordship, these are the official documents he has possessing the.
Navid Singh has rightly said that the inquiry officer said that he has not been able to produce any evidence. First of all, you have to prove.
Well, Lordship, I will satisfy Lordship. Next that Lordship, another day, Lordship. I will satisfy on
Not we have heard it. You take your own time, not another.
But Singulda has dismissed the, or allowed this appeal only on the ground of there is no evidence, Lordship. But he has not denied. He has not denied that he has not done this.
Specifically said, I was not aware of this communication, whatever the
But
communication the
law-
department is relying.
Sorry.
And then he said, even though if it is assumed that I have committed some mistake, it was a bona fide.
But ignorance of law cannot be condoned, Lordship. From
Ignorance
the
of
side of
law, certainly not, but when he come with a
the-
specific case that this communication was never served upon or never, whatever the letter or it has never been communicated.
These are already circulated, Lordship, the case 47 itself, 40.
All revenue officers, whether it was actually served or not.
He is holding the post since 2004, but he cannot say that, you know, on what basis he has registered all these.
Or you should say that in those cases, in another cases, except these registered deeds, 15 or 20, whatever it may be. In some other deeds, he has applied that circular or communication. But in these cases, he has not done.
Not really.
What is that evidence? Particularly when the department came to know that it is undervalued document has been registered, why they have not referred it to the collector?
They have collected on that, I don't know, Lordship.
No, there is a specific, government in the petition. You have not, controverted that. We have heard and, you argue.
On judgment of his there is this is well settled there. Only one copy Lordship. Recent judgment Lordship.
Recent judgment, yeah.
Civil appeal number 11 of 2011. This was there that it is well settled that it is in a disciplinary proceeding. The question of burden of proof would depend upon the nature of charges and nature of explanation put forwarded by the respondent. In a given case, burden may be shifted to the respondent depending upon the explanation. Yes. Yes.
It's against you to give it to.
This case of referred, we have relied in single judge also, Lordship. Paragraph 4, Lordship.
Yeah.
It is well settled that the domestic inquiry, the strict and sophisticated rules of evidence under Indian Evidence Act may not apply. All materials which are logically probative for a prudent mind are permissible. There is no allergy to hearsay evidence provided it has reasonable nexus and credibility. It is true that departmental authorities and administrative tribunal must be careful in evaluating such material and should not glibly sell out what is strictly speaking not relevant under the Indian Evidence Act.
This, learned single is taken into consideration. This
I have relied that.
is taken into. Okay. The matter comes up for interdiction of the petition to behalf of the section 5 of the Delimitation Act in the way of condone the delay of 112. No respondent put in appearance to advocate so and so, however, has not filed any counter to the IEA. But I simply said that the applicants have not satisfactorily explained the thing. Having heard the learned counsel for the part, and after going through, thank you. By going through the contents of the application, we deem it appropriate to condone the delay of 112 days in filing the connected rate appeal. Hence, the IEA is allowed the delay of so and so days in filing the connected appeal is condoned. With the consent of the parties, the connected rate appeal is heard. Fine. At this, at the motion stage itself. Stop. The respondent has approached the writ court assigning order dated 12/11/2013 passed by the who was passed this order? Passed by the disciplinary authority.
Disciplinary.
Name
By the additional chief secretary to the government of Assam, revenue and DM department.
which is that order.
Page 62.
62.
62.
Yes, Lordship.
passed by the disciplinary, 12th of November 2013, passed by the disciplinary authority, that is additional chief secretary to the government of Assam, revenue and DM department, whereby penalty of withholding of 3 number of improvements with cumulative effect has been imposed upon the respondent. The principal allegation against the respondent was that while he was serving as a registering officer at which place?
Kamrup Metro.
Kamrup Metro from 2003 to 2000.
2011.
Reinstated in service on 24/9. He was suspended on 15/3/2008.
2008.
And thereafter he was reinstated in service and posted where?
He was reinstated and posted again.
Reinstated on 24/9/2000.
24/9/2000.
He was posted there while working as the registering officer of Kamrup, district Kamrup Metro from 2003 to 2008.
Posted at Rupohi Nagaon Mene.
No.
2008. He registered 15 number of deeds which were undervalued. The department has alleged that by registering the undervalued deeds, the appellant has, the respondent has violated section 27, capital A in bracket 1 of the Indian Staff in bracket Assam, bracket amendment act 2004. Is also, it was also alleged that the revenue department has issued and communication dated 5/12/2003 to all the revenue officers on the aspect of valuation of land in Greater Guwahati. However, the respondent, without adhering to, without following the said, without following the mandate of the communication dated 5/12/2003, has registered deeds which were registered number of deeds which were undervalued. Full stop. The respondent, in his defense, has raised in his defense has stated that the communication dated 5/12/2003 has never been that the letter dated 5/12/2003 issued by the revenue department has never been communicated to him at any point of time, and therefore the while registering the 15 number of deeds in the year 2007, he failed to apply, he failed to take note of the valuation of the properties which were registered through the deeds. Full stop. The learned single judge, after hearing the learned counsel for the parties, have inclined to accept the defense proposed by the respondent, however, has interfered with the penalty order on the ground that the department has failed to prove the charges against the respondent by producing evidence by producing cogent and reliable evidence. The operative part of the portion of the judgment of the learned single judge. The relevant part of the order passed by the learned single judge is extracted here under para number 16 to 20, 20, 20, and 23. Full stop. It is observed by the learned single judge that the charges leveled against the respondent are were required to be prima facie established in the inquiry through the witnesses who were named and as who were named. Stop. The learned single judge has also observed that the disciplinary authority appears to have proceeded on an entirely incorrect perspective with regard to the burden of proof by holding that the charged officer could not produce any evidence / documentary evidence that he was not guilty in any way. The learned single judge has concluded that the aforesaid approach of the disciplinary authority is contrary to the provisions of law, as the burden of proof, though may not be in strict conformity with the Indian Evidence Act, has to be discharged by the department, which has leveled the allegation against the delinquent officer, and there was a denial of the allegation by the said officer on record. Having gone through, having heard the learned counsel for the parties, and after going through the material available on record, we don't find any infirmity in the observations and the findings of the learned single judge. Hence, no case for interference is made out.
No.
The is made out. The registry is directed to connected with the appeal and treated it as dismissed. Treated is at and treat it as a dismissed.
May I please? One round I have taken the single judge order, 17 and 22 paragraph. These are contradictory. That may be observed.
21 and 20.
17 and 22.
17 and 22.
Yes, please.
So their contradiction.
The contention raised on behalf of the petitioner that he was not aware of the communication dated so and so issued by the Revenue Department on the aspect of that's serial paragraph 22. The single judge is only the part of evidence. That appropriate approach of the disciplinary authority is contrary to the provision of law, as the burden of proof, though may not strictly conformity with the first paragraph. It says that there is no need for strict evidence. Then it says paragraph 22. It says that it is strict.
Said we may not accept it, whatever the defense he has submitted, but at least you should discharge primarily the burden that you have not.
Taken this ground,
You are simply saying that since he has not produced any evidence, therefore that he is not guilty. The burden is not vice versa. Sir. It can't be vice versa.
Our ground is that since these are the official documents, there need not be problem. Yes, sir.
There are two IA.
That's it. One for stay.
IA number so and so is disposed in view of the fact that data field has already been disposed. IA number so and so is disposed.
For admission, item 4.
May I please, Your Lordship? That here is the petitioners are the in evidence of the Batipa Gav Panchayat matter. The as per the, my lord, SOP, Annexure 2, so
First of all, satisfy how this PI is maintainable in delimitation matters.
yes, my lord, already my lordships have the lordships has passed an order.
Which order?
In another case, my lord,
Yes.
similar case, my lord, that is also delimitation case.
What order we have passed?
That is why they have challenged, not impugn order. That is why they would withdraw the case and to file a representation. That is the case. I got it. Similar case, my lord. This is the Gaon Panchayat delimitation case. This is a district Dhubri, my lord.
The same order?
My lord, I'm not speaking about because our case is something different.
What different?
Different is
First
that,
of
my lord.
all, this is your, whatever it may be, 11 persons have challenged the delimitation proceedings, fixing of headquarter or something, or changing the boundaries of so and so. So how whole villages are being affected by that, sir? Only 11 persons out of the 2,000 residents have
Our
challenged that. You may
representation,
have your individual grievance, but not as a PIL.
my lord, that is a 200 odd as per my representation. It is already annexed.
Whatever it may be, sir, even
So,
though
my lord, once the
many persons may be in favor of that delimitation.
no, my lord, entire there is a total numbers of voters 2,606.
What we are saying, we are not saying that your challenge is without any merit, but what we are saying that how PIL is maintainable.
The PL, my lord, that is the thing. Is it the violation of the SOP, my lord?
As violation of SLP, challenge it separately, individually. I'm not saying anything.
Because it is a because entire people will suffer, my lord.
Sir, in fact, none of the, despite issuance of the show cause notice or the notice in advance, no villager has ever objected.
My lord, we have to submit a
Has not filed any objection.
Yes, my lord, we filed in, my lord, representation.
Later on, after delimitation.
Not delimitation not made.
Sir,
They have notified
procedure
only.
is provided that the draft notification would be published. Any person aggrieved by it may file their objection. None of the villager has filed any objection to that.
Initial, there is a two minor notification. One is, my lord,
Whatever it may be, we are of the prima facie view that in such matters, PIL is not maintainable. You may
similar
have
case also, my
ground
lord,
for
has
challenge this delimitation process, but file it individually, separately, or whatever the inappropriate proceedings, not in PIL.
my lord, similar case also accepted, my lord, admitted, and they have given the
Where is
opportunity.
that admission, sir? Where is that? Here we have dismissed it.
But dismiss it because of, my lord, they have no challenge. Otherwise, they are
okay.
That is why.
Yes.
But kindly see, there is a initially, my lord, kindly see, 17/9/2024, the notification was issued. We have no objection because we have no objection. Well, neither my petitioner in evidence another new.
Apart from merit,
after
about the maintainability of the PIL.
Because everybody has a no personal interest. This is the interest of this society, my lord. Because in our that is why they filed an PL, not for individual, my lord. That is why, my lord, if it is, my lord, it is notified, it is accepted, then everybody will suffer because the infrastructure of this present Gaon Panchayat, having all the infrastructure and the newly created Gaon Panchayat, there is a, my lord, no school, no, it will record for, even then this Gram Panchayat, there is the river bank of the, my lord, Borak Valley. It will be 6 months in the rainy season underwater, my lord. See this situation. That is, lordships, the petitioner before your lordships humble praise that, my lord, that is totally illegal. That is the impugned notification 16/10/2024. We have a no objection, even the no till date 17/9/2024. This is annexure, my lord. Annexure 3. Our impugned challenge is annexure 4. Even then, my lord, 24/10/2024, we have submitted the representation till that there is no response from the ends of the respondent. Otherwise, everybody will suffer.
Your lordship, they are only basis of apprehension, your lordship.
Not apprehension.
Where is that?
Already notification is made, not implemented. There is a 2 notification, my lord. Kindly see, this is interesting. If there is only 1 notification, it is matter is something different. Annexure 3, my lord, annexure 3, already they have notified. Ignoring that notification and fresh notification after 1 month, they have notified. This is my challenge. Annexure 3 and Annexure 4. Annexure 3 was earlier notification. There is no objection raised by this entire Gaon Panchayat, newly created Gaon Panchayat and previous Gaon Panchayat. This is my basics, and we have given a lot of grounds. What is the newly created Gaon Panchayat? There is a number of voters is number for 1700, our is 2600, and there is a 3. We have a 3 polling station. They have only 2 polling stations. How it can be, my lord? This is entire, my lord, resident people will suffer. This is totally violation, my lord, and discriminatory, my lord, notification. Already in court.
So PIL is not maintainable. Sorry, sir.
Well, kindly see, there is a 2 notification.
Whatever it may be, sir, you may have a very good case on merits, not on PIL. You may challenge it in appropriate proceedings, individually or collectively or whatever it may be, not as.
Well, I'll withdraw this case and fine. I will given liberty. My lord, even given maybe not to pass any
By
order.
way of this PIL petition, learned concept of the petitioners have challenged the validity of the notification dated 16/10/2024 issued by the District Commissioner Kachar, Chairman of the District Delimitation Commission Kachar, whereby the Badri Par Gaon Panchayat under Banas Kandi Development Block at village Badri Par has given a new name and notified as the headquarters of Gangapur Badri Par Gaon Panchayat under Rangpur Development Block at village Gangapur. Full stop. The petitioners, there are 12 petitioners who have filed this PIL challenging the validity of the said above referred notification, while claiming that the said notification is going to affect 1,000 number of residents of village Badripa.
Yes, Madam,
Badri
2,600.
Full stop. Prima facie, we are of the view that the delimitation process is purely an administrative exercise and comes within the domain of the administrative authority. Even though if the petitioners are aggrieved by the delimitation proceedings, it cannot be said that they are representing the will of they are representing the whole villagers who may not have been affected by the delimitation process. In such circumstances, we are of the view that a PIL petition challenging the delimitation proceedings is not maintainable. At this stage, learned consent for the petitioner. The PIL petitioner has prayed that he may be allowed to withdraw this PIL petition, however seeks liberty for the petitioners to challenge the delimitation proceedings by way of appropriate proceedings before the appropriate court. Dismissed with liberty as plain, dismissed as withdrawn with liberty as plain.
Oblige, Your Honor.
Item 5. Item 5.
Yes, ma'am.
Lordship, Deputy Commissioner has issued order, Lordship, on 23/9/2022. There is communication gap between bank and circle officer, Lordship.
There is a
Communication gap between bank and
now what happened?
circle officer. Now, Lordship, they have verbally stated me that this week they will decide a date for
by what time?
that they have to go, Lordship, to the office of the circle officer, Lordship.
My lord, we have already approached. They already moved.
But Deputy Commissioner has already issued the order on 23/9/2022, Lord,
What order?
regarding possession.
But that's right. That has been issued, but they are not,
Acting
the
upon
officers
it.
are not cooperating. That's why only they have approached this court.
Let it be after vacation, Lordship. I shall complete my instruction. In the meantime, they may fix a date for possession, Lord.
So you are assuring that the authorities will pass an order.
I shall ask them to do the needful, Lordship. Already, I have informed the Deputy Commissioner, Lordship.
What happened then? You have already.
He said, I
informed
have already issued a order to the circle officer, and second order is not.
So what the circle officer is doing then?
Lordship, circle officer is not a party here, so only one case circle officer is party. I shall complete my instruction after vacation, Lordship.
These petitions are filed by the petitioner bank, essentially raising a grievance that the respondent number 2, that is the deputy commissioner, Nagaon district, Assam, is not proceeding the is not acting on the proceedings initiated by the petitioner bank according to the provisions of section 14 of the SARFAESI Act. Stop. It is contended that the proceedings were initiated when
Initially, on 15/6/2022.
in the June 2022 and thereafter again
On
reiterated
27/5/2000.
reiterated in
27/5/2024.
reiterated in May 2024, May, June 2024. But the respondent number 2 is not responding to the request made by the petitioner bank to take steps for securing the possession
My lord.
possession of the properties mortgaged with it on account of failure of the borrowers to pay the due loan amount. So, para learned counsel appearing for the respondent number 2 has submitted that some more time may be granted and assured this court that by the next date of hearing, the respondent number 2, that is district, by the next date of hearing, the deputy commissioner Nagaon district Assam will take necessary steps, will pass necessary orders on the proceedings initiated by the respondent, by the petitioner bank under section 14 of the SARFAESI Act. List after the vacation. Or file an affidavit that we have taken these steps. Close this off.
Other
5, 6, 7, 8, and 9.
9.
What are same?
5, 6, 7, and 8.
What about 9?
9 is Lordship, as per telephonic instruction, Lordship, there is cases pending in civil court and DRT, Lordship. So they requested for some more time to issue the order. Verbal instruction, Lord.
But there is no stay order, your lordship. And DRT original application has been filed by us.
So what happened? What's going on?
Your lordship, we have filed an application on 14/6/2024 before the DM concerned at Jorhat for allowing for passing an order under section 14. And besides that, we have also filed in section 19 application before the DRT. So both are parallelly can go. So there is no bar. But on the verge of pendency of the OA original application, they are not passing the order by the DM, your lordship.
Lord. After Lord, bye.
If your last opportunity is granted to Ms. R.B. Bora, the government advocate of Assam, to file response to the petition filed on behalf of the bank.
Your lordship, if this order be passed,
Lord, deeply obliged.
your lordship, if the order be passed, we can at least execute, your lordship. It's in secured.
Deeply obliged.
Item 10.
May I please, your lordship?
Lordship, we are before your lordship against the order passed by the National Consumer Commission, my lord. Whereby, my lord, the order passed by the State Commission has been, my lord, modified.
Order was passed under section, by the National Commission.
Lord,
This order is passed while exercising powers under 19.
19, my lord.
What is the perimeter provision in the Act of 2019?
My lord,
Section 19's perimeter provision in the Act of 2019.
2019, lordship,
Is there any,
lordship,
because in this,
lordship, after the one judgment, my lord,
that we have referred to that Delhi High Court judgment.
not that, my lord, Delhi High Court, my Supreme Court judgment, my lord. That is, my lord, Universal Sampo General Insurance Company Limited. Thereafter, my lord, their direction was given for the, my lord, to file before the jurisdictional high court.
Another thing. But here, the instant appeal has been filed under section 19.
19.
Consumer Protection Act 1986.
86, my lord. Thereafter,
What about this, during the pendency of this appeal,
appeal, my lord,
when
the
this
new
2019
Act
Act
has
came into force,
Form.
repealing that, what would be the effect of that?
my lord, and as per that act, my lord, I think, my lord, the section 19 has come to, my lord, section 42, I think. 67, my lord. 67, no, 67 to review. Appeal. It was appeal, 40, my lord, 41. Appeal, 40.
This is
Itu section 224. Kami dia appeal kihat kal. Bukan pilih yang abang. Kalau aku kesan kamu ni. Section 24 berubah. Itu aku. First appeal. Itu no. Section 51 lordship appeal to national bank.
But granted you compensation of rupees 10 lakhs.
My lord,
This 23 lakhs, on what basis the state commission is awarded that compensation?
my lord, that is on the basis of the, my lord, jewelries which we have given, my lord, as a list, my lord, at the time of filing the complaint before the, my lord, bank. And my lord, the fact, my lord, is my lord,
The initial complaint was by the complaint bank authority. The complainant estimated that there may be valuable item in the locker worth rupees 20 lakh. This is kept in the locker are depicted in the complaint. Complaint in their evidence as category said the ornaments kept in the locker were daughter-in-law and daughter. And when they receive and when the person hires the locker in the bank, he must have in some valuable kept in the solution given by the is not exuberant. Her capacity of earning saving of rupees a full length of service in college may not be doubted. Without there being any proof that these jewelry is
in this,
so much of weight, how many gold, how many silver.
In a similarly situated case, my lord, the this order passed by the National Commission, my lord. There's the ornaments were, my lord, stolen from the property. They were recovered. Then also, my lord, 30 lakhs has been.
Attention, safety, security, compensation be just and reasonable. Loss injury suffered to the complainant. Compensation raised towards daily compensation 50 the mental agony and 10,000 as a cost of living is on the higher side. Both the
But
courts,
simply, my lord, it is said, my lord, it is on the higher side, my lord.
what basis? It's higher or lower side?
My lord, it is simply stated, my lord, that it is on the higher side, my lord, nothing else, my lord.
So state commission has
My lord, we are
state commission has come to this conclusion that 23 lakhs on what basis? What was the evidence before it?
On the basis of the list we have given, my lord. Before,
How many? Where was that list?
my lord, that is that, my lord, page that we have exhibited. That is as page 62, my lord. 60, 61, 62. 61 and 62, my lord. That has been
gold chain.
My lord, this is the list. This list, my lord, we have not given, my lord, haphazardly, my lord. This is the record which we used to.
Some certificate by jeweler that this is what the weighing of this, how many carats of gold was there. You have simply made a list that.
My lord, bank has also not denied that, my lord, these things are there, my lord.
Things are there, no?
Things are there, my lord. Yes, but the my lord, valuation, my lord, these are low. Most of the jewelers, my lord, they are given in the, my lord, as gift.
Doubt about that.
At the time of marriage, my lord, at the time of gift, my lord, these things are there, my lord.
The cost and the weight, the jewelry, where is that, sir? Some proof of the jeweler that he has you purchased it in so and so year by so and so.
Some of them are street on, my lord. Some of them are, my lord, gifted during marriage, my lord. Some of these things are there, my lord. Where from, my lord, these things will come, my lord? These certificates from the jewelers, my lord, and all, my lord. My lord, we are fighting the legal battle from, my lord, 2011, my lord. And it is not that we have given this.
Simply said gold coin of what weight?
That is written, my lord. That is written in the, my lord, weight we have given, my lord, on the other column, my lord.
Where is that?
At page 61, lord. See, we may come to page 61, my lord.
Yeah.
Gold coin, my lord, 28.3 grams, my lord. Necklace 3 piece, 75 grams, my lord. One both 4 piece, 55 grams, my lord.
Or something. Where is that sleep?
My
lord, the bill of the jeweler.
My lord, how can I give the, my lord, purchase of the street hunts, my lord?
Suppose abhi aapke paas mein, if you income tax rate is there, they'll ask for everything. that where is that document, from where you have purchased, how much price, everything they'll ask. You can't have this in a guesswork.
My lord, yeah, my lord, my lord, I am placing, my lord, two judgments, my lord, where, my lord, this order passed by the National Commission has been, my lord, interfered in similar cases by the Honorable Apex Court, my lord.
Forum and the National Consumer both have passed the judgment on the basis of their guesswork and nothing else. No determination.
My lord, that is, my lord, what, my lord, that is, my lord, the Lordship may kindly go to, my lord, the Supreme Court judgment, my lord, where, my lord, the order passed by the State Commission has been appealed, my lord, in similar case, my lord.
Admission of this returnable trial. And you are also insisting us to do the same guesswork. Okay, you have said it's okay, fine.
Item 11.
Lord, I'm appearing for the respondents, sole respondent, my lord. 2 weeks time to file a short reply, my lord.
You have not filed till date.
No, my lord. So for the first time, it has come after the
yeah.
notice, my lord.
Okay, Mr. Das put an appearance on behalf of the sole respondent, pays a short, pays some time to file. Counter to the restitution time paid for a grant. Mr. You
May I pray for a date, my lord? Yes. Highly honored.
Item 13.
My lord, in this matter, I am led by Mr. K.N. Chaudhary, Senior Advocate.
Lordship, I'm appearing for respondent number one, Lordship.
respondent number one.
Lordship, one prayer matter may be listed immediately after vacation.
Why, madam? Why? Mr. Chaudhary, she's looking at you. Give answer. Why?
Immediately after vacation.
All right, my lord.
Then one thing.
Maybe on 6th, my lord, on the reopening day.
They is operating in this.
Because those days operating, my lord, nobody is gaining, my lord.
Okay, let me consider appearing for the respondent number one. Please. Some time. The ground that the arguing consent is not available or what? Arguing consent is here or what?
He's not here.
Is not available today. 3 o'clock. And in September, is this matter on
Or 8th, my lord.
8th
Yes.
of January.
Interim.
Interim to continue করবে লাগবে। My lord, the interim order will continue till then.
Interim order is pending to continue till next week.
Diplom.
Item 14.
Another bench. The Honorable Justice Worship Goswami cannot be a member.
Not sure.
For hearing, item 17.
The similar matter, your lordships fixed those matters, my lord. I have checked, those were parted. Perhaps that's
In
why,
fact, today.
yes, I have got a copy of the order also, my lord. That is read appeal number 152/2024. So this,
List along with that whenever.
yes,
this is-
yes, my lord, yes.
List along with the writ appeal number 152/2024.
My lord. Obliged.
List along with writ appeal number. In all these 18, 19, 18 and 19.
Highly obliged.
So have you,
I have done some homework, my lord. I have got, my lord, I'll try to persuade your lordships, my lord. On both the points, my lord. Highly obliged.
18, 19. Yes. Yes, sir.
Item number 18.
18.
18 and 19.
18, 19. There's some instruction was set for. Last order, 19/9/2024.
And from IIT.
You are for? You are referring for whom?
Respondent.
Respondent. In fact, in these matters, there is a query on the part of the from the court how these appeals are maintainable. Regarding the maintainability of the appeal, and I requested the counsels appearing for in other cases, similar cases, Mr. Das and other. We are in the midst of the argument regarding the maintainability of the writ appeal. You have to address the court on this point regarding the maintainability of the writ appeal.
They have filed it.
The members of the bar are required to assist the court on this point. Sir.
This is an issue, Milord. Nobody is going against anybody, Milord.
Yeah,
The parties are
naturally,
assisting your
because
Milord.
today
Whether-
you are appearing from here.
Exactly, Milord.
Tomorrow you may
I
appear
have
from
seen,
that
Milord,
also.
in that case also, Milord, both the sides are arguing.
Arguing.
Yes, yes.
That's right.
Yes.
Lordship, these matters may be posted after reopening. This
Along with
We have fixed it along with the similar matters.